Very good evening, students. Very good evening, Manisha. Very good evening, Mausumi. Okay, students, so let's start today's session now. First of all, I welcome each one of you to my YouTube session on the Specific Relief Act 1963. So let's start with my brief introduction. First, my name is Sandeep Khatri. I've done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I'm a teacher. I'm teaching law for more than 5 years now. My areas of specializations are the constitutional law, criminal law, commercial law, family law, and law of torts. This is my profile on Unacademy students. Please do follow it to get all the updates about my special classes and plus courses. And this is my Telegram channel where you can connect with me to ask for any kind of queries related to judicial preparation. Okay, this is my code KHATRILIVE, KHATRILIVE, which you can use to get free access of all the classes, all the special classes on Unacademy app, and in addition to that 10% discount for all your plus courses as well. So this was about me. Very good evening, Anu. So now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel at any point of time that something is not clear to you, you can ask your questions in the comments and I'll answer accordingly. So what all I am going to cover in today's class? In this class, I am going to start with the important mains questions from section 26 till section 33 of the Specific Relief Act. Okay. Very good evening, Aprajita. Okay. Okay, students, so let's start this class. The first important question is explain doctrine of rectification and when instruments may be rectified. Yes, what is going to be your answer on that? After that, I'll come to section 26 on this. I hope the question is very simple and a direct question. Like they are asking you about the doctrine of rectification and when instruments may be rectified. So the answer will lie under section 26. Yes, Aprajita. Answer is section number 26. So let's discuss section 26. If you have any doubts related to section number 26, this is your time to ask questions. Okay. This is your clause 1, which says when instrument may be rectified. Okay. So when through fraud or a mutual mistake of the parties of a contract or other instrument in writing. So this is your first condition. That is, in writing, if there is a case of fraud, if there is a case of mutual mistake, which means a bilateral mistake from both the parties, not being the article of association. Article of association is kind of, you can say, the exception. This cannot be rectified as per to section number 26. Reason being, company law will be applicable on that. Okay. It does not express their real intention. When you exactly fall into rectification, the concept of rectification, the concept is very simple. When it does not express the contract or any other instrument, does not express the real intention of the parties, then you can rectify it. Now, who can rectify? Either party or his representative. They can rectify this, either party or their representative. The plaintiff may in any suit. So the plaintiff or the defendant. Fine. Okay, I'm not getting any questions, so I'm moving on. This is your clause 2, students. If in any suit in which a contract or other instrument is sought to be rectified under subsection 1, the court finds that the instrument through fraud or mistake does not express real intention of the parties, the court may in its discretion. Please do underline this term. The court may in its discretion, which means it is the discretion of the court whether they want to go for rectification or not. Just let me open the section number 26 in my Act as well. Exactly. The concept of rectification has not been amended in 2018 amendment. It is still the discretion of the court. Okay, I hope it's clear. Now coming to a contract in writing may be first be rectified, and then if the party claiming rectification has so prayed in his pleadings, the court method may be specifically enforced. I hope everyone is clear with the third point as well. Do I need to explain you anything regarding this? Students, if you have questions, do ask. And if not, just quickly give me a thumbs up. I'll move to the next ones. Okay. So suo motu, this relief cannot be claimed, provided that where a party has not been claimed in the relief in the proceeding, the court shall at any stage amendment bhi ho sakti hai. Amendment bhi ho sakti hai. So any questions from section number 26? Any questions? So now if I need to conclude this concept, students, of section 26, let me use the whiteboard, and after that we will move to the next concept. If I need to conclude this whole concept of section 26, what does this say? The objective is कि whatever the mutual mistake was, to correct it. Rectification means to put it correct. What was the real intention of the parties? And this, once this has been rectified, this is not the legal right of the parties. Mind it, student. This is not the legal right. This is the discretion of the court. This is the discretion of the court. The court will decide whether they want to give the benefit of section 26 to the parties or not. And once students, once the document has, once the contract or other instrument has been rectified, then in that scenario, after that, specific performance may also be claimed in that case. That's it. Okay. So no questions at all. So I'm moving to the next question now. Question number 2. What is recession? So students, sorry for the spelling mistake. The spelling is wrong. What is recession of contracts and when it is adjudged? Explain the circumstances when recession may be refused. I hope कि कल students ने कुछ questions भी पूछे थे regarding section 27, but we were not having that time. Sir, ये AOA पे क्यों नहीं apply होता है? Okay, Manisha, answering to your question, section 26 will not apply to article of association because we do have a specific law on that, and that is of the company law, the company's law. Okay, so the company's law will be applicable if you want to correct anything that has been written in article of association. So you know the amendments will be as far as the company law is concerned. Okay, yes, Mosmi, today we are going to cover 27 clause 2 as well. Okay, now I'm starting with this. First, let's start with 27 clause 1. Any person interested in a contract may sue to have it rescinded, and such rescission may be adjudged by the court in any of the following cases, namely, where the contract is voidable or terminable by the plaintiff. That is the first condition, which is basically, if I need to tell you the section numbers, you can write down section 19 and 19A of the Indian Contract Act, which means if there is coercion has been involved, coercion, fraud or misrepresentation, then it will fall under section 19 and it is voidable by at one of the parties against whom the coercion, the fraud or the undue the 3 points: coercion, fraud and misrepresentation, to whom the party to whom this has been committed, that party can void for that option, where the contract is voidable or terminable by the plaintiff. Students, please confirm I am still connected with you all. Please just confirm I am connected with you all. Okay, fine. Okay, now I'm continuing with this. So I was giving you the example of section 27 clause 1 subclause A. Perfect. Thank you very much. Now I'm giving you some examples. So the example I have given you is section 19. So section 19 of the Indian Contract Act. So there were 3 concepts. The first one is coercion, the second one is your fraud, and the third one is misrepresentation. And as per to section 19A, there is undue influence. So these are the examples of this one. Now coming to the clause B, where the contract is unlawful for the causes not apparent on the face of it, and the defendant is more to blame than the plaintiff. If that is the case also, then also you can rescind it. Now one more question I want to put before coming to clause 2 of section 27, because you all are not asking, so here is my turn to ask the question. Students, section 27 is giving you any specific relief or not? Answer in the comments. Be quick with your reasons, yes or no. Section 27 is giving you any specific relief or not? Waiting for your answers. Aprajita, yes. Sapna, yes. Yes, students, I want answers from you. You can even write don't know. That is also acceptable. Okay, only Manisha is saying no. Students, when you are saying that section 27, now I am concluding this. When you are saying this, that section 27 is giving you any specific relief. So what kind of specific relief section 27 is giving you? Can anyone answer me the reasons for their answer? Mosmi, you are basically ending the contract here. Rescission here means put an end. So what specific relief you are getting here? This is basically opposite. Section 27 is basically opposite of any specific relief. Fine. You are actually putting an end. You are actually putting an end here. So the answer is section 27 is not giving you any specific relief. Now coming to the next question, section 27 clause 2, which says notwithstanding. Students, this is again an important term which you will read again and again in your barracks. Notwithstanding here means despite of anything which you have read in subsection 1, the court may refuse to rescind the contract. Which means whether rescission is your legal right or not, no. It is going to be the discretion of the court. It is going to be the discretion of the court whether they are going to rescind the contract or not. Now, when the court may refuse this, point number 1, where the plaintiff has expressly or impliedly ratified the contract. Now let me give you an interesting example here of this one, the first one. I'm using the whiteboard for this. So let's take this example, students. There is Mr. A and there is Mr. B. Okay. Now they are having a contract where they are having mutual mistake. And in that scenario, one of the parties, students, please be attentive. This is interesting and important example. A and B are having a contract and they are having mutual mistake in it, and A filed a suit under section 26 against B to rectify it. Now just assume that in this case court allowed the rectification. Now you tell me, if the court allowed the rectification, which means now these parties can perform this contract after the changes, whatever the mistake was, after the changes they are allowed to perform the contract. But now Mr. A has filed another suit under section 27 to rescind it. अब बताओ अलाउड करेंगे या नहीं करेंगे? आंसर मी दिस फाइनल क्वेश्चन. अब रिसाइंड के लिए अलाउड करेंगे या नहीं करेंगे? Manisha, no, not now. Okay, what about others? Students waiting for your answer. Okay. निखिल, आई एम एक्सप्लेन अटेंटिव. निखिल, अगर दो पार्टीज हैं म्यूचुअल कॉन्ट्रैक्ट, ठीक, सॉरी, बिकॉज ऑफ म्यूचुअल मिस्टेक, ठीक है, यहाँ पे एक पार्टी सूट फाइल करती है 26 का टू रेक्टिफाई इट, और कोर्ट यहाँ पे अलाउड भी कर देता है रेक्टिफिकेशन. अब उसी कॉन्ट्रैक्ट के लिए अगर यहाँ पे सूट फाइल किया जाता है अंडर सेक्शन 27, तो क्या उसको रिसाइन करना चाहिए या नहीं करना चाहिए? यस. स्टूडेंट्स, आई होप कि अभी बफर नहीं कर रहा है, क्योंकि मेरे एंड से प्रॉब्लम होना तो नहीं चाहिए, बट अगेन हो रहा है तो ओके. सो मैं फाइनली आंसर कर रहा हूं स्टूडेंट्स. इसका आंसर रहेगा आपका, आप ये जो है रिसाइंड अब नहीं करवा सकते, अब पार्टीज को परफॉर्म करना ही होगा. दैट्स इट. दिस इज बेसिकली योर दिस वन. नाउ आई एम टेलिंग यू द कॉन्सेप्ट. सी, notwithstanding anything contained in subsection 1, notwithstanding anything contained in subsection 1, matlab despite of whatever the concept that has been explained under section 27 clause 1, the next concept, the court may refuse to rescind the contract. Court may refuse to rescind the contract. Why? Because where the plaintiff has expressly or impliedly ratified the contract. Okay, this is what I have given you the example of. Next, students, where owing to the change of circumstances which has taken place since the making of the contract, not being due to any act of the defendant himself, the parties cannot be substantially restored to the position in which they stood when the contract was made. Now let's take one example of this one, students. I am giving you the example of this now. Second point. A and B, and there is a contract between the parties, and in this case A has passed the goods, B has to pay the price. But if B has used some goods, in a sense that these goods cannot be returned to Mr. A. They cannot be returned to Mr. A. Now in that situation, students, if this cannot be returned, which means now you cannot put an end to the contract. So this is basically this point. Okay, I'm repeating myself. When the parties cannot be restored to the same position, what is the objective of section 27? The objective of section 27 is simple enough, that to restore the parties back to the same position. And if the goods have been used, which means now you cannot rescind the contract. Okay. Next one, students, where third parties have, during the subsistence of the contract, acquired rights in good faith without notice and for value. If there is a contract between two parties, and because of that goods have been transferred, now to the party to whom the goods have been transferred, that party has actually made a contract with the third person, and now the goods are delivered to him. In that case also you cannot rescind the contract. Last one, when only a part of the contract is sought to be rescinded and such part is not severable from the rest of the contract, which means when you cannot apply the doctrine of severability. When you cannot apply the doctrine of severability, in that situation you cannot rescind the contract. That was your section 27. Anything which is still not clear to you, feel free to ask questions in the comments. Yes. After that, I'll come to the last section and we will conclude this class. Here is the last question, students. Explain the scope of cancellation under section 31 and when cancellation may be ordered. And here comes the answer under section 31. Sir, 2B. Amit, I have just explained, okay, 2B. Okay. Amit, I am giving you an example, so please be attentive. Let's take an example, Amit. I delivered some goods to you, okay? And you have used those goods. And those goods are not in a position that you can give me back those goods. So is there any point to rescind that contract between us? Now will I demand the goods or the price? I will only demand the price. I hope now it is clear. Okay, let me give you any other example. Just give me a second. Okay, done. Mosami, are you done with the section 27 2 clause B, or I need to come up with any other example? Waiting for your confirmation, Mosami. If you are not clear, please do write. I will give you any other example. Okay, done. Okay, students, this is your last important section, that is of cancellation. Now, any person, everyone please read with me, any person against whom a written instrument So this is important, students. Written instrument is void or voidable, and who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. So let's take an example. Okay, Mosmi, let me complete now section 31 first, then I'll move back to the another one. Let's take a very simple example for this, students. Cancellation of instruments. If there is a contract between A and B is a minor and B is a minor, now can they have a contract? And that is also of property, where B is selling the property and A is paying the price. Now this is going to be void ab initio. Okay. In these circumstances, the papers, the documents of this house, if they have been on the name of A now, B should cancel this instrument or not? Answer me this. यहाँ पे इस डॉक्यूमेंट का कैंसिलेशन होना चाहिए या नहीं होना चाहिए फॉर द बेनिफिट ऑफ बी? Yes. I'm raising a question, students. Manisha, first one to answer yes. What about others? Yes, Aprajita. And what are your reasons, students? The reasons are very simple. Now coming to the reasons of the answer. Now let's reread it again. Any person against whom a written instrument is void or voidable and who has a reasonable apprehension. So in my example, the minor has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury and may sue to have it adjudged void or voidable. Okay, and the court may in its discretion, again students, the point to notify here, in the case of cancellation as well, it is the discretion of the court that they want to cancel it or not. And if the instrument has been registered under the Indian Registration Act, the court shall, now here it is, the court shall also send a copy of its decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his books the fact of its cancellation. Done? Any questions from section 31? After that I will move back to section 27 because you still have some doubts on this. Yes, now any questions on section 31? Megha, are you asking a question about this? Section 31 clause 1? Or you were answering, I guess? Okay, this is clear. Done. Okay, perfect. Now I'm moving back. Yes, students, now you want example of which one? I guess you were asking for this one, example for this, 2C. Okay. Okay, I'm giving you the example, Aprajita. Be attentive. There is A, there is B. A has passed these goods to B and B need to pay the price. In this case, now these goods are with B only. B entered into the contract with C to sell these goods. अब goods किसके पास है? C के पास है. Now you tell me, in this situation, A have sold the goods to B and B sold the goods to C. Who has the possession of goods? It is the C. Can A recover those goods now? Can A recover those goods? Answer me this. Aprajita, yes. And now read this. Please. When third parties have, during the subsistence of the contract, acquired rights in good faith without notice and for value, in that case, what will happen? The court may refuse to rescind the contract. Clear? Okay, Megha. What if there exists no reasonable apprehension? I guess you are asking about section 31. Answer to your question, किनका question था ये? Yes, answer to your question, Megha. If there is no reasonable apprehension that such instrument may cause serious injury, then obviously the person, if there is no reasonable apprehension, the person will not move to the court, and if the person will not move the court will not order for the cancellation of that instrument. Done? Aprajita, A cannot claim from C. A cannot claim from C. See, students, when the third parties, see what is the objective. Aprajita, please listen carefully. I am concluding this for you now. First, listen this. What is the objective of section 27? The objective of section 27 is that if you are going to rescind the contract, it will put an end. It will put an end. Which means before the contract, whatever the situation was, the court will restore the position. Whosoever has paid for something, उसको वो पैसे मिल जाएंगे. Whosoever has delivered the goods, उसको goods मिल जाएंगे. But suppose if the situation is such that court cannot, restore the parties to the same position which was before the contract, then in that case court will refuse to rescind the contract. Done? Anything else, students, related to section 27 or 31? Anything which is not clear to you? Chalo. Okay sir, clear now. Perfect. Chaliye. So these were your important mains questions, students. These MCQ we have already covered in the last class. So anything before ending this class? It was very tough to be a teacher. It's okay, Amit. Amit, you could ask this question directly as well, without any emotional blackmail. 31 again. Okay. Amit, now listen this. Okay. Amit, I am giving you an example. I gave you a proposal that, okay, chalo. App ही use कर लेता है, whiteboard use करता है. Everyone be attentive. I am concluding the concept of 31. Now A, just give me a second. A put a gun on the head of Mr. B and told him, A put a gun on head of Mr. B and told him to sign on these papers so that his house will be given to Mr. A and Mr. A will give him 25 lakh rupees as well. Now you tell me what kind of a situation this is. In this scenario, students, this is a clear case of gun, which means clear case of coercion. which means this will fall under section 19 of the Indian Contract Act, which means voidable at the option of B here. Voidable at the option of B. Now when the B can make it void agreement as well, which means he will get his house back. But the question is, students, here the important question here is, what about this document? If you are at the position of B, and this is the question to all my students who are attending this live, do answer me in the comments ki if you are at the position of Mr. B, whether you want to cancel these documents or not, whether you want to cancel these documents or not, or you were like ki I got the house, I got the position of my house, now I don't need or I don't care whose name it was on the name of title of the house. Yes, you want it to cancel or not? Amit, waiting for your answer. Amit is saying yes. Okay, Aprajita, yes. सर माई क्वेश्चन टेक प्लीज. मौसमी, आपका कौन सा क्वेश्चन मैंने मिस कर दिया है? सर इफ रीजनेबल एप्रीहेंशन. ओके मौसमी, लेट मी जस्ट कंप्लीट दिस वन, उसके बाद मैं इस क्वेश्चन पे आ जाऊंगा. ओके ठीक है. मैंने इतनी बार पूछा है कि एक सेक्शंस को अब हम पता क्या कर रहे हैं, एक बार हम 27 पे जंप कर रहे हैं, एक बार 31 पे, तो ऑब्वियसली कंफ्यूजन तो हो ही जाएगा फिर. ठीक है. यस 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 यस. ओके, नाउ आई एम कंक्लूडिंग सेक्शन 31 क्योंकि अमित आपका आंसर करेक्ट आ गया है. सो लेट्स कंक्लूड दिस नाउ. लेट्स कंक्लूड दिस नाउ. नाउ any person against whom a written instrument is void or voidable, जो मेरे एग्जांपल में भी था, and who has a reasonable apprehension that such instrument if left outstanding may cause him serious injury, may sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. बताइए, any question from section 31 now? पहले सेक्शन 31 कवर अप करते हैं, उसके बाद कहीं और जाऊंगा मैं. आई विल नॉट टेक एनी क्वेश्चन ऑन सेक्शन 31 आफ्टर दिस. ठीक है, क्योंकि मैं जैसे ही 27 पे जाता हूं फिर आपका 31 से क्वेश्चन आ जाता है. यस, नाउ एनी क्वेश्चन फ्रॉम सेक्शन 31? चलो डन. आई एम वेटिंग फॉर 10 मोर सेकेंड्स. कि हो सकता है आप टाइप कर रहे हो, उसमें भी टाइम लग जाता है ना कई बार. चलो क्लियर है. अब आते हैं इस पे. अब इस पे इनका क्वेश्चन आया मौसमी का. नाउ आई एम टेकिंग योर क्वेश्चन मौसमी. सर इफ रीजनेबल एप्रीहेंशन कॉज आफ्टर इंजरी. अच्छा, आपका तो इसी क्वेश्चन है. इफ रीजनेबल एप्रीहेंशन कॉज आफ्टर इंजरी, even in that case Mosmi, file a case under section 31 and you can cancel the instrument. From section 27 now. It was not that difficult, by the way. Okay.